is go over for a little PowerPoint, hit a few odds and ends, call the calendar, see who's here, and see what we're doing. Any housekeeping before we jump in other than that?
No, sir.
Okay. All right, perfect.
The judge available right here.
Okay, got it. Perfect. All right, everybody, good morning. This is the Spalding County State Court. My name is Josh Thacker. I'm your judge, and this is the probation and non-jury calendar. I want to start out by saying that here in the Spalding County State Court, we believe that each of you, as you interact with this court, deserve the respect and the dignity that you'd wish for someone you care about. We will extend that to each and every one of you as we interact with you all here today. Hey, don't talk during court. Our goal is to return you to your lives promptly. I will have very little patience with anyone who disrupts court as we're trying to make that happen. I do have one virtual person, Mr. Dorsey. We're going to need to see if you have permission to appear virtually. Go get a pen and a piece of paper no matter what, and wait for me to speak with you directly. All right, everybody take out your phones out of whatever pocket, purse, or pouch you've stashed them in and turn it off. They keep ringing in the courtroom and I'm out of patience. So please don't come to a probation hearing and then have your phone ring. That is a wicked combination that you do not want to explore. All right, this is the correct courtroom for you if you're on probation with the Spalding County State Court, you're being supervised by the sentence enforcement team, or you have some other motion you need me to hear. This is not the correct courtroom for you if you were issued a citation by the city of Griffin Police Department and you're supposed to be next door in the city of Griffin Municipal Court. If you have any doubts, talk to the bailiffs, but they're usually really good about checking everybody in on the way in. And I think everybody in here is probably where they're supposed to be. And of course, there might be Superior Court upstairs. There is. Okay. I don't have Marty's approval on that one yet. All right. So what we're going to do is I'm going to call the calendar. When you hear your name called, stand up. If you have an attorney, let them announce for you. I don't have one to trade with you. You got them both? Oh, good. Thank you. Excellent. All right. So we're about to call the calendar. If you have an attorney, which there's attorneys here, several of y'all represented by them. Once you stood up, let them announce for you. That's what you brought them here to do. If you're here without an attorney, then these are for you. So if you're here without an attorney, then you're going to go say probation or a license permit or some sort of motion. Okay. All right. Any housekeeping before we jump in? Piper?
No, sir, other than Mr. O'Dell.
Okay, got it. Mr. Nice, any housekeeping? Okay.
Not that I know of.
Yeah, that's okay. If we bump into it, we'll stop and deal with it. All right. First name on the calendar is Jamarcus Baker. Jamarcus Baker, answer your name. No?
Bench warrant bound for referral.
Warrants granted. All right. Raphael Benefield. Benefield. No?
State would ask for bench warrant bound for.
Granted. Andre Bess. Yeah, excellent. Thank you so much. Corbin Brown. Okay. All right, I'm marking touchstone off, everybody, off the calendar. Devontae Crawley. All right, thank you. And everybody, please mark that is also a pretrial intervention case.
Judge, I apologize. Is Mr. Crawley here?
Yes, that's okay. I saw you were talking, and that is always okay. So I'm happy to pause and let everybody get caught up. Okay, let's go ahead and talk to Dorsey. I think I can sort this one out pretty quick. Goldie Dorsey, I sent you an unmute request. If you'll approve that, please. There we go. All right, can you turn your camera on, please? All right, you there? All right, you got about 30 more seconds before I move on to the next, so. Keeps muting and unmuting and muting and unmuting and. All right, you there? Okay. All right, so I'm issuing my ruling. So Goldie Dorsey requested permission to appear virtually. That virtual permission was denied. I've also tried to talk to Goldie Dorsey this morning and try to get a handle on what's going on. There's no unmuting. There's no, oh, look at that. So there's no unmuting and now she's gone from the system altogether. So, all right, we're done with that one. State of motion,
State move for benchmark bond forfeiture, Your Honor.
granted.
Judge, did we skip Davis?
Yes, but it was unintentional.
Okay, I was just wondering
no.
if I missed something.
No, that was me messing something up and I appreciate you helping me fix it. So Natarius Davis,
That case is off, Judge.
that's the answer.
Oh, well, there you go.
All right, on to the next one. Rakima Ellis,
That case is off, Judge.
Flint. Sandos El-Tarani.
Good morning, Your Honor. Attorney David Ghazi. This Mr. Harmon is in court today, and the special permission is yet held. It isn't probation for her to enter into pretrial diversion. And she's filled out the paperwork and she was subject.
Okay, that sounds great. So she doesn't need to see me formally. If you've got the paperwork from the solicitor's
already-
office.
It's already signed,
It's already
given to
done.
Mark.
All right, do y'all need?
We've got to meet with her. We have
Okay.
not done that, Judge.
All right, so let's have her come around and sit in the jury box here in just a little bit. The probation team will pull her back into this room here and talk to her a little bit, get everything signed up. And then you don't need a hearing with me. Once she's met with probation, signed all the paperwork, then you'll be good to go.
Okay, and so are we, am I excused?
I mean, if you've already signed the paperwork, you're welcome to go, but she's not going to be gone for at least an hour. So, so that what you do next is your business if you've already signed everything. But she'll be here for about an hour while we finish everything.
Thank you, Your Honor.
Thank you. All right, Linda Gaston.
Judge, for the record, that's a pretrial.
Oh, thank you for that. Yep, y'all stand up when your name's called. Okay, that one's good. On to page 3, Rashawn Giles. All right, thank you. Brian Grady. Grady? No?
State moves for benchmark bond forfeiture, Your Honor.
Okay. Jonta Jackson.
Here, probation.
Thank you so much. David Jester. All right, thank you very much. That's page 3. On to page 4, Marcel Johnston.
It's Markel.
Markel, thank you. Names are important. You want to desk get somebody?
Judge, I don't think this one made the calendar. I unfortunately don't. I think it was just missed from the calendar. It was e-file code.
Okay, that's what matters. What matters is was it e-filed
It was
correctly?
e-filed. I don't recall the exact reason.
That's all right.
Use Carly?
Clintia Johnson.
It's a written on present probation.
Okay.
It's the whole 9,005 correct, we should get out for hearing.
Okay, that makes sense. And I see where you wrote it on the very end. So
Sorry, Judge, I just couldn't remember what happened with that one.
that's all right. Y'all are my collective memory, so that's perfectly all right. The answer is we're good. She's here. She's in the hopper. And we'll circle back to her. All right. Markel Johnson is here. Brian Kelly. Let's see. I don't see that one in my pile. Yep, there it is. Okay. Brian Kelly? No?
Probation,
Oh.
I'm sorry. Probation, Warren and Cohen.
Granted.
Sorry. It's such a pleasure to have actually two people to
Yes.
worry about.
Sorry, y'all just got to learn how to dance. It'll be all right. Ashley McGee.
That case is off, Judge.
Excellent. Devin Merritt.
Motion.
All right, that's your motion. Okay. All right, Mr. Odell's here. All right, everybody go on page 4. All right, on to page 5. Mr. Odell's 1, 2, and 3. We can skip those. Kel Ponder.
Good morning, Your Honor. Mr. Ponder is present, Judge. There are 2 cases on the calendar, Judge. One I represent Mr. Ponder on, the other I do not. 1610 is the bond revocation hearing, Judge, but I represent him on 444, the second position of the 2.
Okay.
We do have a negotiated plea in my case of 444, Judge. The other matter for bond revocation, even though I do not represent Mr. Ponder, there has been an offer made by the state that I'd like to relate to him.
Okay.
At that point, potentially a pretrial conference, and then
Okay.
if need be, a bond revocation matter for Mr. Ponder and the board.
All right, Mr. Ponder, you understand that Mr. Sellers represents you on one of your 2 cases. And so he is offering to provide a little bit of assistance, but not representation on that second case. And so he's going to talk to you about it, but that does not mean he's representing you on it. So this is an awkward moment that you're going to need to be very careful and intentional that you walk your way through. Okay. All right. Thank you very much.
Thank you,
So.
Judge.
All right. Gerald Reed. Is this just a show cause?
Yes, Judge.
All right, so this is a show cause petition. Gerald Reed, answer your name. All right, so Gerald Reed is not present. It's a show cause. I have 3 options on the table, and given the fact that Gerald Reed is not present, I'm going to order that the above named defendant has failed to appear. This was properly served, and therefore the probation sentence shall continue as ordered. Done. All right, Callie Sanders. Thank you.
Judge, for the record, that is a pretrial diversion.
Thank you. All right, everybody got that? All right, Mr. Ryson, why we call that one out is because sometimes those pretrial cases become a conference that y'all need to have. So I'm just giving you what that means.
Understood, Your Honor.
All right, David Thomas. Motion?
Motion.
Okay. Got it. All right, Tanisha Thomas. Tanisha Thomas. No?
State moves for benchmark bond forfeiture.
Granted.
Judge, for the record, that was a pretrial as well.
Oh, thank you. Pretrial warrant, we're good to go.
I didn't need that.
Brandon Williams. Brandon Williams. No?
State moves for benchmark bond forfeiture, Your Honor.
Granted. Granted. All right, that's the end of page 6. Top of page 7. There's a bond mod hearing with Ebony Willis. Mr. Shade's here.
That's my case, Judge. I think that we can probably resolve that with a short bench conference.
Okay, that sounds great. And then Johnson, we already dealt with on the front. Okay, is there anybody whose name was not called? It says stand up for me. Anybody whose name was not called? All right, we're exactly where we should be, and we're right on time. So good to go. All right, so you all want me to make any announcements other than the conferences?
I'm sorry, Judge.
No, it's okay. You're doing many things. I just said, do you want me to do anything other than announce the conferences?
No, Judge, I would like if this myself, the state, and you could, free trial on Mr. Odell.
Yes. So what I'll do is I'll step out of here and I'll just set up shop in the conference room.
Yes, sir.
Because I think a couple of folks wanted conferences, and so y'all can just rotate through as you're ready.
Yes, sir.
So, all right, Piper, anything else? All right, y'all anything? No, that's the public defender's office, but they're not here today. So, okay. All right, so here's what's going to happen next. So we're exactly where we should be on time. I've called the calendar. Everybody knows where they are, and we have what we're doing. Let me tell you what's going to happen next. So what's going to happen next is conferences. And so with the conferences, what that means to you is the state, for the vast majority of you here on a probation matter who have announced here, the state is going to make some sort of offer to resolve your case. Not everybody gets one, but the vast majority do. So here's what that looks like. The probation office is very likely going to bring you all in somewhere and then bring y'all back into the jury room and have a discussion with you. They're going to have a written offer for you. They're going to go over it with you. If you want to accept it, and you sign the document, right? So if you want to accept it, you sign the document. As soon as you sign the document, you'll be given a copy of it and you'll be free to go. So that's what accepting the offer looks like. You sign the document, you get a copy, you're free to go. If you do anything else, we have a hearing. So I cannot stress that enough. I do not have time for you all to go back and forth all morning about this term or that term. I got hearings to have and a whole courtroom of folks that need to get it done. And so I want to make certain this is very, very clear, is that if you want me to sort this out for you, do the anything else. If you want to sort it out with your own self, then sign the paperwork. Whichever one you choose is fine. But just make certain that we know that this is not a negotiation. It's just an offer and an acceptance or nothing at all. Goldie Dorsey has logged back in, but I've already ruled my decision on that one. So I'm just going to leave Dorsey where they are.
Yes,
All right. Anything else before I step off the bench? Okay. I'm going to set up shop in the conference room. When you all ready to meet with me, just come on back and I'll be sitting in there, signing papers and everything else. All right. With that said, bailiffs, y'all got the courtroom. Okay, you ready, Kathy? So what I normally do at this point is just recall the calendar, figure out what we've resolved. Anybody want to do anything any different than that?
Yeah, so there's still several moving things going on, but we have enough for you to start so we can get moving. So yeah, that's probably the best thing.
Have a plea.
Either that or just start with like Jody and just
Yeah.
kind of move that along.
Jody, what do you got?
So we can let Jody go.
Yeah, Ponder, right?
We do,
Let's do
Judge.
that.
Two cases on Mr. Ponder.
Okay, I'm trying to figure out what's first.
We haven't met with him yet.
Oh, well, let's just do the plea then. That'll be
Yes,
fine.
sir.
You can bring him up.
Thank you, Judge.
We're gonna do it out of order. I kept Marty back there for a while, working out other logistics. And, has he had a chance to fill out the right sheet yet?
We have not.
That's the only thing I need to do the plea ahead of
Okay.
time. So if y'all would just grab that seat right there. Margaret, if you'll
I
give,
have one here.
yeah. It won't take long, but y'all do that and I'll do the Crawley plea and that'll buy you a minute.
Ponder's the last name is Kelly. Kel. See, I have two.
What is your name, please?
Devontae Crowley.
I have it right here. There you go.
All right, perfect. All right, everybody, let's come to order. Mr. Crawley, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, Your Honor, I do.
All right, take your hand down. Mr. Crawley, you're here today on 23 SR 1930 because you're participating in our pretrial intervention program and your sentence enforcement supervisors filed paperwork alleging that you're out of compliance. Do you understand that?
Yes, sir.
And it looks to me like you've reached an agreement with the state today for me to remove you from that program by consent and then accept a plea to close your case. Is that correct?
Yes, sir.
Okay. All right, so let's talk through. So do I have your permission in just a little bit when I'm presented with an order removing you from the pretrial intervention program? Actually, it's right there. All right, do I have your permission to sign this document, which already has your signature on it, removing you from the pretrial diversion program?
Yes, sir.
All right, with your permission and consent, and do you agree that there would be enough for me to remove you from the program if we'd had a full-scale hearing?
Yes, sir.
Okay, then we're good to go. I'm signing that. He's already signed it. This looks great. So Margaret, I'm just gonna give that to you to hold. So that I don't do what I normally do and lose it in my stacks. Okay, now we've removed you from the pretrial diversion program. Now we're gonna do your plea. Are you ready to do that?
Yes, sir.
All right. Mr. Crawley, I'm holding up this self-represented defendant plea rights waiver. Do you recognize this document?
Yes, sir. I just signed.
And do you recognize your initials next to each of the lines on page 1,
Yes, sir.
page 2?
Yes, sir.
And is that your signature?
Yes, sir, it is.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And did you understand everything that's on it?
Yes, sir, I did.
Did you understand that you have the right to have an attorney represent you?
Yes, sir.
And you're here representing yourself?
Yes, sir.
Is that what you want to do?
Mhm.
Yes? Okay, that's a yes. And do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, this case will be closed? Is that what you want to do?
Yes, sir.
All right. Any questions for anything about anything on this document or anything else before we pivot to the facts of your case?
No, sir.
All right. Do you stipulate that you possessed a drug-related object, which is count 2, back on March 7th of 2023 here in Spalding County?
Yes, sir, I did.
All right. Then I'm going to find with your admission of guilt as to count 2 that there's enough for me to take your plea. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I've reviewed the recommendation and I'll follow it as negotiated.
Yes, sir.
Any questions for me about anything so far?
No, sir.
You ready for me to sentence?
Yes, sir.
All right, the sentence of the court is as follows. Mr. Crawley, on 23 SR 1930, count 2, possession of a drug-related object, guilty, 12 months probation, 180 is your fine. You may, count 1 is dismissed. You may work your fine off with community service work. You'll need to follow the general conditions of probation 1 through 14 on the face of your final disposition. The moment you've satisfied your obligations to the court, your case will close. You have 30 days from today if you wish to appeal this decision, and you have 12 months from today if you wish to use your habeas rights. You already know sentence enforcement through the pretrial program, but I assume you've already discussed your next report date with them,
Yes, sir.
and they've already told you when to report to their office.
Yes, sir.
Any questions?
No, sir.
Do y'all need to speak with him at all? All right, then if you'll go with Margaret, she'll get your paperwork ready and she'll give you your last set of instructions.
All right, thank you.
Thank you. All right, that's Crawley. Everybody can mark Crawley off.
Thank you.
Judge, may I approach?
Yes. Ready? All right. You ready on Ponder? Okay, so Kathy, this will be an accountability court plea, Stinson plea, so this will end up being one for you for a transcript. You ready, Mr. Sellers?
We are, Judge.
You ready, Mr. Ponder?
Yes, sir.
All right, state your full name for me.
Caleb Ponder third.
Mr. Ponder, you're here on two cases, 24 SR 1610 and 24 SR 0444. We're doing this plea a little bit out of order in that you would normally have met with sentence enforcement prior to the plea, but I got ahead of them. And so I'm going to go ahead and do this plea, but unlike the plea ahead of you that signed their paperwork and just left, you'll actually go sit in the jury box and wait for them to speak with you, and they'll have a much longer conversation with you after we're finished. Do you understand that?
Yes, sir.
Okay. All right. Megan certainly have that all lined up. All right, Mr. Ponder, we're going to do, honestly, a hybrid of a hybrid. So what we're doing is you have two cases. We're entering pleas on both of them. I'm only going to sentence you to one of them. And then the other one, you're going to go complete the accountability court program. And once you've successfully completed it, the first case will get dismissed and then your probation will start. Do you understand that's what it's going to look like when we're done?
Yes, sir.
Is that an accurate description?
That is, Judge.
Okay. All right. Y'all correct me if I get anything wrong here. All right. So Mr. Ponder, I didn't read out my rights earlier, like I normally do. So I'm just going to start here at this document. I am holding up this attorney and defendant plea rights waiver. Do you recognize this document?
Yes.
And are these your initials next to each of the lines on page 1,
Yes.
page 2?
Yes.
And is that your signature?
Yes.
Did you sign and initial this document after reviewing it fully with your attorney?
Yes.
And did you have a chance to ask your attorney any questions that you have?
Well, we spoke earlier.
Do what?
We spoke earlier.
Okay. So did you have all the time you needed to ask any questions you may have had?
Yes.
And are you satisfied with the job your attorney has done on your behalf?
Yes.
Do you understand? Do you have any questions for me about anything anywhere on this document?
No.
And Mr. Sellers, you reviewed this document fully with your client?
We did, Judge.
And are you confident he understands everything on everywhere on this document?
I am, Judge. And as Mr. Ponder mentioned, Judge, we have spoke about that form itself in prior court cases earlier this morning, and then we signed that as well a few minutes ago, Judge.
Okay, and this is not Mr. Ponder's first run through the court
Correct,
either.
Judge.
And you will actually be also continuing to assist him, if I understand it right, as you are the public defender through the accountability court program. So y'all will continue speaking together.
That's correct, Judge.
You understand that, Mr. Ponder?
Yes.
Okay, I mean, he would anyway, but I'm just putting that on the record since that's there.
Yes, sir.
So, okay, Mr. Ponder, do you have any questions for me about anything before I talk to your attorney?
No.
All right, then let's start with your first case in sentencing order will be 24 SR 1610. That's the DUI. Mr. Sellers, although you're not technically representing him on this case, you are, at my request, assisting the court, and the court is very grateful for that.
Yes, sir.
But do you stipulate for the purpose of this plea that there's a sufficient factual basis for this DUI plea from 9/2/24 here in Spalding County?
I do, Your Honor.
All right, Mr. Ponder, do you wish to enter a guilty plea to that DUI charge?
Yes.
All right, moving on to 24 SR 0444. That's the reckless driving charge. Mr. Sellers, do you stipulate that there's a factual basis to support this reckless driving charge from 8/13/23?
I do, Judge.
That's right, here in Spalding County. That's on me. And Mr. Ponder, do you wish to enter a guilty plea to this reckless driving charge?
Yes.
All right, I'm gonna find that between the attorney's stipulation of the factual basis combined with the defendant's request to enter guilty pleas, that there's enough for me to take both of these pleas. I'm going to find that Mr. Ponder is knowingly, voluntarily, and intelligently waiving his rights and entering these pleas. I've reviewed the recommendations across both of the cases, and I will again acknowledge and thank Mr. Sellers for stepping outside of his contractual obligations to his client to help him with this global picture and to, of course, help the court in getting Mr. Ponder into our amazing accountability court program. Mr. Ponder, do you have any questions for me about anything before I sentence on one of these and send you to the accountability court on the other?
Oh, no.
All right. So the sentence of the court then is anything else, Mr. Sellers?
Nothing further, Judge.
All right. The sentence of the court then is as follows. So again, the structure is going to be 24 SR 1610 is the first case. That's your accountability court case. So I'm actually not going to sign the sentence on here, but what I am going to say is that we're going to set this aside. You're going to sign a reset notice from the clerk's office in just a minute for a check-in. And then actually you're going to go today, this afternoon, to the accountability court, which is upstairs on the second floor. Mr. Sellers will be there. And that's just a good way for you to go, meet everybody, get a feel for what you're signing up for, and start that process. But if you do end up not successfully completing the accountability court, which is my job to say awkward things like that out loud, I would sentence you, if you were removed from the program, exactly according to these terms that are in front of me. Do you understand that, sir?
Yes.
All right. Is that correct so far?
That's correct,
All
Judge.
right. I'm trusting of you to tell me if not. So,
Yes, sir.
all right. And then moving on to the last case, I am sentencing on this case. So in 24, anything else, Mr. Sellers?
Nothing further, Judge.
All right. Anything else, Mr. Ponder?
No.
All right, moving on to 24 SR 0444. Reckless driving, that's from 8/13 of 23 here in Spalding County. I find you guilty. It's 12 months probation, $13.92 is your fine. You may work your fine off with community service work. 1 day to serve in the Spalding County Jail with credit for time served on that charge. You will follow the general conditions of probation 1 through 14 on the face of your final disposition. This reckless driving charge is consecutive to 24 SR 1610. So what that means to you is it will not begin until one of two things happen. We're going to go with the more optimistic first. The more optimistic is you successfully complete the accountability court program. The first case is dismissed, and that's when the second case would start. The other pathway forward is you're not successful in completing the accountability court program, and I remove you from the program, and then this case starts, but it would only start after the sentence for the DUI then runs. You understand that?
Mhm.
Yes?
Yes.
Perfect. All right. So if you do end up on this case, no alcohol, no illegal drugs, no hemp products should be tested for those. You will obtain a Georgia driver's license, show sentence enforcement. 240 hours of community service work at 6 hours per week or more. Substance abuse evaluation within 90 days and DUI school within 60 days. You have 30 days from today if you wish to appeal this decision, and you have 6 months on this case if you wish to use your habeas rights. Okay, so that sentence is signed. So Miss Margaret, you can take this one apart and go ahead and give them their copies. And then the white original goes to the solicitor's office on the accountability court. Does that make sense? Okay, perfect. All right, anything else, Mr. Sellers?
Nothing further on those, Judge.
Mr. Ponder, I have to admit, you've been on my radar for a while. I really feel like if we could have just frankly gotten a good handle on you and gotten you moved into our accountability court program, we could help you with your struggles. I've been having you on my calendar since I took office. And I'm sad that you have this moment, but I want you to hear me say, I'm pleased. I think this is the first opportunity we've really had where we have enough hold on you to get you over to an amazing tribe of human beings who participate in the program, and an amazing group of people such as Mr. Sellers who are dedicated to their sobriety and stability. And I know you won't feel it until you feel it, but I look forward to that moment when you realize it's a better pathway forward. Okay?
Yes, sir.
All right. Thank you very much. If you'll sit in the jury box and wait for the sentence enforcement team to talk.
Thank you, Judge.
That's it for you, right? Great to see you as always. Okay. Did that buy you some time?
Yes, sir.
Okay. All right, well, let's talk to Mr. Odell. Mr. Odell, come on up to the podium. Actually, let's just grab him, let him have the seat there, Margaret, and pull the mic over for him. All right, Director Matthews, if you'll raise your right hand, I'm gonna swear you in on everything. Director Matthews, do you solemnly swear or affirm that all testimony you will give in all matters today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you're sworn in across the board. Mr. Odell, I'm gonna swear you in. Are you ready?
Yes.
Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down. State your full name for me.
Larry Edwin Odell.
Mr. Odell, you were here today on several cases. You're here on 22 SR 0958, 22 SR 0960, 22 SR 0961, and 22 SR 0959. According to my docket in front of me and the records that I'm looking at, we had this set up for a hearing maybe a month or two ago, maybe a little longer.
2 months ago.
2 months
A little
ago?
over, 2.5 months, something like that.
Okay, so, and that you had requested the opportunity to get an attorney,
No, sir.
a private attorney. I wrote that on there. Defendant wanted a private attorney.
My thing was, I said I didn't want an attorney, period. I can handle the private. This is a violation of probation, right?
Yes,
I mean, why would I need an attorney for that?
okay. Well, my note was that you'd requested the opportunity to get a private attorney and I moved it to here. So, so if you're saying you don't want an attorney and you want to represent yourself, that's fine. Am I correct in what you're hearing?
Yes, sir.
What's the deal with the felony upstairs?
That's about 4.5, 5 years old. That's gonna be thrown out. The person who the drug belonged to, was given a ride.
Oh, I wasn't looking for the facts. I was just looking
Well,
for what's going on with it.
It should be dismissed for long.
You've got counter call in
Yeah, I was incarcerated. for
9
this right
days.
here.
Okay,
Yeah, I gotta go on the 8th.
you're set for trial on that
Yes, sir.
this month. Well, it's September,
Yep,
and you do have an attorney on that one.
yes. Sir.
Who's your attorney on that one?
I'm not sure her name. I had it in my wallet and her phone number. Sure, I wasn't able to call her.
Looks like Tiambre Callan, public defender,
Jonesboro, yeah. Conflict lawyer.
conflict lawyer. Okay. All right, so you're saying it's going to be dismissed. I'm saying it's not dismissed.
It's not yet, no.
And I think you're being held on a warrant out of that case.
Yeah, so I already took care of that too. All they done is gave it to the judge upstairs. The DA's office, other word.
Okay. Well, I'm noting for the record, and I think this is really important because you've been in several months on my case,
Yeah.
that you are being held without bond on a felony warrant in that case. And there would be no action I could have taken at any moment before today that would have secured his release from the jail in any way. Because I'm reading the bench warrant in 25R 282B as in Bravo.
I was
What was that
incarcerated.
number again, Jeff?
The felony case upstairs is 25R 282 or -282B as in Bravo. And I'm looking at this warrant and it says that he is to be picked up and held.
I was in jail when the warrant was issued, sir.
That's not my problem.
I know, they already gave the paper for incarceration was already delivered upstairs.
All right, well, that's not my circus and these are not my monkeys. So that's something you're gonna have to deal with in Superior Court. I'm just noting for the record that if I were to order you to be released
I
today,
would be released.
you would not be
They
released.
told me out the jail that I would.
You would not be released. You can say it all day long.
All they got to do is proof of incarceration will be delivered to the court upstairs and I will be released. That's
Is
what-
there any scenario where I say to you what the record is showing to me? and
Right now,
you
yes.
don't- And is there a second scenario where you don't cut me off where I'm
I'm
talking?
sorry.
So I need two scenarios explored with you and I need them explored right now. Okay? I've been very patient with you interrupting me every time I've opened my mouth. But frankly, I've been punishing my court reporter and I'm done punishing my court reporter. Okay? So the next time you open your mouth and interrupt me, we're going to stop the hearing immediately right there. And I'm going to send you back to the jail and I'll reset you for another day.
Yes,
Okay? Don't do it again. You've reached the end of my patience.
all right.
Okay? I'm telling you what the docket is showing. I'm not telling you that I'm right. I'm not telling you that I'm wrong, but I am simply being courteous to you. I am trying to provide you with information that is available to me that I thought might be helpful to you. But you're too busy arguing with me about it that you're not even listening to the fact that I'm trying to be courteous. Do you understand why I'm raising my voice a little bit and I am frustrated?
Yes, sir.
Because you have proven to me that no good deed goes unpunished. You are sitting in front of me on a probation revocation. This is a good moment for you and I to build a little bit of a relationship instead of being adversarial when I'm just trying to share information with you that I thought would be helpful.
Yeah.
You have the floor.
Yes, sir. I wasn't trying to interrupt you as much. I apologize for that. But I had been told something completely different. I understand where you're coming from, what you're reading right there and what it says. But I had already had it explained to me and they took care of it for me. And that just hadn't been taken off the thing yet.
Okay.
That was the way it was explained to me anyway. I'm sorry if I was interrupting, sir.
Okay. Well, I'm just telling you that I don't see what you're saying in the docket. I'm not saying it's not true, but whatever it is you think is true is not there. I also see another new case. 26 FAH 0652. This one looks like it's ours, y'all. Looks like simple assault and criminal trespass, misdemeanor charges.
What was
Judge,
that case
those are
number
the-
again, Judge?
That's the charges that are violating his current.
And this one
probation.
here?
Yes, Judge.
Okay, 26 FAH 0652. I'm saying that because if the state wants to review it, and will y'all kick that door shut? If the state wants to file an accusation, I can go ahead and arraign him and we can get that thing moving. If the state wants to review it and dismiss it, that's fine too. I don't have a preference. I'm just saying that there's options. And there's some sort of motion in here. Yeah, I don't know what it is. There's some sort of motion in here from him.
Is it back from like 24, 25, Judge?
Yeah.
So those are his motions. You banished him on 23 SR 0050 back on August 22nd of 2024. And those were his motions for the court to reconsider that.
Got it. Okay, well then we're on the same page. So, okay, so I'll just leave that with the solicitor's office. If y'all want to review that and either dismiss it or file an accusation, I'll be happy to get it moving in the right direction. Okay, so that's where we're at. So you're officially saying, am I correct, Mr. Odell, that you do not want any attorney representing you on this case? Is that correct?
No, sir. I really don't see why I need one.
Okay. Do you understand that if you asked me to, I would appoint the public defender's office to represent you at no additional charge?
Yes, sir.
And that would be free representation that you would not have to pay the county back for?
Yes, sir.
And knowing that you could have a free attorney representing you, are you knowingly and voluntarily and intelligently choosing to represent yourself in these matters?
Yes, sir.
Okay. I'm going to find that the record is clear that I've offered the public defender's office at no additional charge and that they would absolutely represent him and that he has declined representation and that he's knowingly, voluntarily and intelligently waiving the right to counsel and choosing to represent himself in these matters. All right. So that brings us to that. Is the state, Mr. Eisen or Ms. Sexton, Ms. Sexton, I guess you're more knowledgeable on it. Or either one of y'all fill me in on where we're at if y'all are ready. And if not, why not?
So, Your Honor, as you stated, those charges haven't been accused yet, so the state would like to exercise their right to a continuance on this and propose a reset of September 17th.
Okay. I don't show that y'all have asked for a reset previously. I show the last one was at the defendant's request. Mr. Odell, do you understand the state is asking me to reset it to September 17th?
Yes, sir, but I don't have that much time left. I have 5 months left on a DUI. The
Okay,
next one is fully maintained lane. They were sentenced, and I was sentenced continuously. That means I gotta finish one before the next one starts, right?
correct.
Okay, well, how are they violating one that I haven't even started yet, is what I'm getting at. I should done got out on the time I've done so far for that first one, and then started my second one.
Okay. Well, if you think that's a valid argument, you're welcome to argue it at our full scale hearing. That may prove to be true, but we'll sort that out on that date. So, all right. So, Mr. Odell, I think that it's in the court's interest to give the state what I would normally give anyway, which is one continuance. You've used yours. That's how we got to this court date. They're asking to use theirs. That's only 3 weeks out from here. And frankly, how much time do we have left on everything?
For all cases, we have 1,980 days.
Yeah, so I got plenty of time. So, okay, so I'm gonna trust that the state will either bring me an accusation or a null pros on the new charge on that date. That way we can have that hearing
What day is it, sir?
September 17th.
Okay, well, I'll be in court upstairs on the 21st if my jury trial starts that day.
Yeah, I'm also a little curious about how,
I will have that taken care of before I'm back here, sir.
that's a good point. I don't want to do it before the felony case. I really don't want to do it before the felony case. Give me just a second.
The state's not hung up on that date, Your Honor. We can adjust.
Well, given that his trial is set in September, if I were to move this to early October, right? That would put it after the felony case. We would know what's going on. We would have a defined, this is what they did.
Your Honor, may I?
Yes, you may. Thank you for
I was
asking.
going through a lot of medical treatments. I was in service and drank toxic waters at Camp Lejeune. I'm in the middle of getting all kind of tests. I got 3 tumors. They were still going to do biopsies a week on the 22nd of April. I hadn't been able to get none of this done. So basically, I'm being sentenced to a death sentence because I can't get none of this cancer stuff taken care of. And I don't know why, because I didn't do anything wrong that day. I never got a criminal trespass warning. I didn't put my hands on nobody. I got shot and kicked down some steps. And the officer that arrested me has been arrested himself with some serious felonies, being held and can't even get out of jail. That's the witness they have against me.
Sounds to me like you got a pretty good leg to stand on. We should sort that out. Just remember that the issue for this is very narrow. It's
Yeah.
whether or not I banished you from Spalding County and whether or not you were back in Spalding County. And then the second question is whether or not you got arrested in Spalding County while you were not supposed to be in Spalding County. So it's a pretty simple set of questions that I'm just going to need to have a hearing on. And I'm aware that I see that your lead officer is an officer who has his own criminal charges. We'll have to sort that one out on that hearing. So I'm just letting you know that this question is very simple to me. You were banished. Were you found in Spalding County? And obviously the second set was, were you arrested in Spalding County on these new charges? What's the answer to those questions? I don't know. I don't officially know, but we'll find out. But I'm not going to do the 17th. I really want to know what's going on with these felonies before we do it here. So let's pick a date.
10-1 or 10-8 or 10-29, Judge.
Are any of those better logistically wise than any others?
Not in my perspective,
Okay,
Judge.
let's do 10-1 then. That's as close to after the felony case as we can. And is the state offering any sort of consent order on this, or is this just a,
There was a consent offered. He refused that, Judge.
Yeah.
okay, what is that offer?
It is 510 days with credit for time served and terminate the balance of the current case. And that he would then need to leave for approximately 48 months from release for consecutive cases, 3 consecutive cases.
I'll
All right.
sign that.
Mr. What?
I'll sign that now. Cause the way it's getting put off, I'll be out by the time all this gets to court.
That's not
I'd-
exactly true.
It'd be
As far
right
as
at
possibilities
December.
go,
Well, I get 4 for 1 if I get in honor, don't
that's outside of what I care about.
I? Okay.
That's outside of what I care about.
Yeah, I just signed a consent if that's okay. I mean, it's getting put off too long.
All right, let's all sit very quietly. Director Matthews is going to move about courtroom, get it lined up. Once we get him finished, we'll be done. But what I do want to do is go ahead and have him sign an arraignment date. That way we got him to come back. Oh, that's right. We don't have an accusation. How about this? Good quality. So you're going to need to make certain we have good quality contact information because the state's going to file that accusation and we're going to get it signed. All right, let's go off record, get everything signed, and then we'll come back on.
No.
So Mr. Odell, and somebody correct me if I'm wrong on this, but your banishment still stands. Your banishment still stands. You've just signed your consent order and that closes out this hearing and we're done with this and you're finished. But I just want to point out to you that you are arrested on these new charges in Spalding County and you're in the Spalding County Jail while you were banished from Spalding County. So if the same thing happens again, I will not honor a consent offer and I will bring you back and we will explore whether or not I should just put you in the jail for the remaining 2,000 or almost days. And I don't want to do that. And you don't want me to do that, but it's my job to say awkward things like that out loud. Okay?
Okay, on that, I removed my signature.
I'm not having a discussion with you about it. I'm just giving you a heads up of what I'm going to do if certain things are placed in front of me in a certain way. And I'm just trying to make certain that you're not surprised. Again, this is just a courtesy of me saying, hey, I don't want to surprise you, but I also want you to know that if you come back again on a revocation for being back in Spalding County, I'm not going to show you any mercy.
Okay,
And that way you're not surprised by it. Fair enough?
fair enough.
Okay, fair enough. All right. Well, good luck to you and your felony upstairs. Go wherever Piper tells you to go. All right. Gaston? All right. Good morning.
Good morning. Good morning.
If you'll state your full name for me.
Linda Marshall Gaston.
All right, perfect. If you will please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down. Ms. Gaston, you're here today on 24 SR 1033. And according to my calendar, you're in our pretrial intervention program, and your sentence enforcement supervisor has filed paperwork alleging that you're out of compliance with the pretrial program. Is that correct?
Yes, sir.
Okay. What I'm looking at in front of me is paperwork where you acknowledge that, that the allegations are true. I remove you from the program with this document, and then we enter a plea and close your case with this document. Is that correct?
Yes, sir.
Excellent. Excellent, excellent. Okay. Okay, so let's start with the removal from the pretrial intervention program. Do you stipulate and agree that there would be a factual basis for me to remove you from the pretrial intervention diversion program?
Yes, sir.
Do I have your permission to sign this order, which already has your signature on it, removing you from the program?
Yes, sir.
Okay. All right, so Morgan, I'm gonna give you that one to you. All right, so I've officially signed the paperwork, removing you from the program with your permission. You've already signed that one, so we're good to go. Any questions on that phase before we do the plea?
No, sir.
All right, now back, your case is on here. So I'm holding up this self-represented defendant plea rights waiver. Do you recognize this document?
Yes, sir.
And do you recognize it? Do you recognize your initials next to each of the lines on page 1,
Yes, sir.
page 2?
Yes, sir.
And is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And did you understand everything that's on it?
Yes, sir.
Are there any questions I can answer for you about anything anywhere on this document? Anywhere?
No, sir.
All right. Did you see on here where it says you have the right to have an attorney represent you?
Yes, sir.
And you're here representing yourself?
Yes, sir.
Is that what you want to do?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, this case will be closed? Is that what you want to do?
Yes, sir.
All right. You are charged with one count of obstruction of a law enforcement officer, and that here in Spalding County on March 1st of 2024, you did fail to obey lawful commands from law enforcement officers and who are giving you those lawful commands here in Spalding County. Did you do that?
Yes, sir.
All right. I'm gonna find with your admission of guilt, there's enough for me to take your plea. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I've reviewed the recommendation and I'll follow it exactly the way you've negotiated.
Yes, sir.
Do you have any questions for me about anything, no matter how minor?
No, sir.
All right, you ready for me to sentence?
I am.
All right, here we go. Ms. Gaston, on 24 SR 1033, this is the obstruction charge from March 1, 24. I find you guilty. It's 12 months probation, 179 is your fine. You may work your fine off with community service work if you wish. You'll need to follow the general conditions of probation 1 through 14 on the face of your final disposition. Your case may close the moment you've satisfied your obligations to the court. You have 30 days from today if you wish to appeal this decision, and you have 12 months from today if you wish to use your habeas rights. You've already met with sentence enforcement, is that correct?
Yes, sir.
And you've already been given your first report date?
Yes, sir.
Okay. If you will follow Miss Margaret's directions here, she's going to get your paperwork finalized, get your copies, and then you'll be good to go.
Thank you.
All right, thank you. What are you doing?
That's the removal.
Let's go off record for a minute. You just don't move. You're good. State your full name, please.
Callie Ann Sanders.
Ms. Sanders, you're here on 24 SR 0652, and you are also in our pretrial diversion program, and your sentence enforcement supervisor has filed paperwork alleging that you are out of compliance with the program. Do you understand what you're doing here today?
Yes, sir.
Which means I have two steps to this hearing. The first hearing is to determine whether or not to remove you from the pretrial diversion program. And it's my understanding that you've worked out a consent with the state where you want me to sign this order stipulating to the violations. In other words, agreeing that the violations are true and removing you from the program. Is that correct?
Yes, sir.
All right. So, and then the next thing we do is this plea that's also in front of me. Is that correct?
Yes, sir.
All right, then that's what we're going to do. So with your permission, and I see that you've already signed this order. I've signed the order now removing you from the pretrial diversion program. So Clint, if you'll just hold that just for a second. And now we're going to move to the plea. Anything else on the pretrial before we go to the plea?
No, sir.
All right, then I'm holding up this self-represented defendant plea rights waiver. Do you recognize this document?
Yes, sir.
And do you recognize your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
And is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
I did. Yes, sir.
And did you understand everything that's on it?
I did. Yes, sir.
Any questions I can answer for you about anything anywhere on this document?
No, sir.
All right. Did you see on here where it says you have the right to have an attorney represent you?
Yes, sir.
And you're here representing yourself?
Yes, sir.
Is that what you want to do?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial. This case will be closed. Is that what you want to do?
Yes, sir.
Okay. Ms. Sanders, did you here in Spalding County back on October 10th of 2023 obstruct law enforcement officers by failing to obey their lawful commands?
Yes, sir.
All right, I find with your admission of guilt as to the obstruction of a law enforcement officer charge, there's enough for me to take your plea. I find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I've reviewed the recommendation and I'll follow it. Any questions for me about anything before I sentence?
No, sir.
Okay. Ms. Sanders, on 24 SR 0652, obstruction of law enforcement officer, I find you guilty. It's 12 months probation, $100 fine. That's the part that they're having to sort out. So your final sentence, when all the dust settles, may look slightly different than that,
Okay.
but it'll be the equivalent of that once we figure out what the two systems need. Does that make sense?
Yes,
Okay, I
sir.
just didn't want you to panic if you saw a slightly different something on that. All right, you may work off your fine with community service work, follow the general conditions of probation 1 through 14, and your case will close the moment you've satisfied your obligations to the court. You have 12 months from today if you want to use your habeas rights. You have you have 30 days from today if you want to appeal this decision, 12 months if you want to use your habeas rights. If you will please go stand by the door. Clint's going to get your paperwork moved all around, and then he'll meet you at the door and give you your last set of instructions.
Thank you.
I think that one goes over to Marty. No, that's okay, Clint. I'm the one passing it the wrong way. It's all right. Okay. Do y'all want to call the calendar? What do you want to do? You have a case ready?
Judge, you've got two pro se, requests, if you wanted to do those two first.
That'd be fine.
That is Devin Merritt
Okay, Merritt, come on up.
and David Thomas.
Thomas, coming up and sit on the front row. All right, Mr. Merritt, raise your right hand. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name for me.
Devin Lamar Merritt.
All right, Mr. Merritt, you are here on 22 SR 0607, and according to my docket in front of me, you filed a motion asking me to make some changes to your probation. Is that correct?
No, sir. I'm not on probation.
Okay, what do you got? Oh, dang it. Okay. Do you have your paperwork with you?
Yes, sir.
Okay, I just realized that's on me. I did not say for you to, I'm actually going to let James take a look at it back there, and that's my fault. I should have said it. So I'm gonna have you go back and talk to the last bailiff back there. He's gonna review your paperwork, figure out what it looks like, and then tell you if you need more or pass you back up to me. And that's on my, I should have said that at the beginning of court. That's my fault. All right, come on up. All right, what's your name?
David Allen Thomas Jr.
All right, and are you on probation?
No, sir.
All right, what are you looking for? Same thing?
It's a record restriction or expungement. I'm having an issue with a conviction in state court here for simple battery when I was charged with simple battery family violence. The clerk's office says it's being reported correctly. The GCIC says it's correct, and the FBI is saying that I have a family violence charge. And I've appealed to them, and they're sticking by it. I've been to the clerk's office like 3 times trying to work it out with them. I've got my state background, the GCIC, and somewhere something's not being communicated, or I don't understand what's going on, but this was recommended that I request this.
Okay, let me pull your file up. This is 22 SR 0499.
Yes, sir.
Your birth date in 76?
Yes, sir.
Okay.
There's a lot of David Thomases.
Yes, there are. So you had a second case, 22 SR 0421. That one was reduced to disorderly conduct.
No, sir, that was a separate incident, separate date a year later. And that was dismissed.
Judge, if I can,
Yeah.
he has came into the clerk's office quite a few times, and on our end, it was initially simple battery family violence charge. When he pled out to it, it was reduced to simple battery, no family violence. So we've also checked with GCIC, and everything on our end is entered correctly. Like you can see it amended, where he pled guilty to just the simple battery, but
I think I know with that tells me what the issue is. So thank you for that. That's what I needed. Okay, then I'm very confident I know what's going on here because you're
Okay.
saying the FBI is the one telling you it's family violence.
Yeah, I have the response from them.
Oh, I'd love to see it. That'd be great. Pass it off to Clint.
See.
Are any state of Georgia resources telling you this information, or is it only the federal government?
Federal,
Okay.
ATF and FBI.
Excellent. That not excellent, but that tells me I'm right. And
And this.
okay, so this is a very simple but difficult situation for you, which is it's called the separation of powers between the state government and the federal government. So the federal government can do whatever they want with whatever information they have in whatever way they want to use it. The state government is not going to act outside of the way we've sent this in. And there's a case on this because I read it about 2 years ago where it said that if the federal government chooses to bring in a case that I'm pleading out as just simple battery, which I am looking at it, I've confirmed that what Ms. Evans is saying is correct, that they have the authority to look into the underlying facts of the case and to determine if they want to hold it in their records, however they want to hold it in their records. And I, as a state court, not state, but a state of Georgia judge, have no authority to in any way tell a federal agency how they are to interpret it. My only guess would be that there are several very high quality federal defense attorneys in the Atlanta area, and to tell you to go find them and talk to them, because I would imagine there's some sort of motion or petition or something. I'm guessing. I don't go to federal court. I didn't do federal work when I was in private practice, but I'm imagining there's some sort of review option. I can't imagine there not being, and you can ask. But unfortunately, you've hit a very, very real, very litigated separation of powers issue between the state and the federal government. and I can't tell the federal government what to do with our information.
Yeah.
So not the information, not the answer you want,
No.
but it is at least hopefully information you can act on.
With this,
So.
my biggest,
does that make sense?
my biggest concern is, any possible future employment that this could affect. Because I'm disabled, I'm getting older, I have a part-time job that I'm good with, but you never know.
Sure.
And I don't know if this would affect any possible employment in the future.
Well, that's a third question, which is what could and would a private individual do with this information? So now you've added a third category of people I don't have any control over.
Right.
And so the answer is that, yeah, what a private individual does with this in an employment decision is their business. But I'm looking at it, Ms. Evans has confirmed it, it's not going in as a family violence case, and it's not pled as a family violence case, and it's not marked that way in any way whatsoever for us. So, I mean, I do see that you had, Brad Moody's office back on the day. You're welcome to reach out to them.
Well, it was James Bowles, and I just found out today he's a judge now
Yes.
in Henry County.
I was pretty excited about that choice. I think he's going to be a great judge, but
Yeah.
yes, he was with Brad Moody's office. So reach out to them if you want, or go find somebody else. But unfortunately, that's the best answer I've got at this moment.
Okay.
So sorry about that, but I only extend to the state of Georgia.
Okay. Thank you, sir.
Good luck to you.
Thank you.
Yes.
Has done everything. Your man is glad is here. All right. Your man is glad. Let's just be done with it. If you ask Angel to draft an order for me, because he's saying it. Look,
Yeah, if you'll ask Angela to do that. Okay. All right. So on a side note, I just reviewed Mr. Merritt's paperwork, and he qualifies. And I'm asking Angel, she'll draw an order up for me to sign. So, Mr. Merritt, you just sit tight. We're gonna get you an order in just a bit. Good job on getting all your stuff fixed. All right. What else?
Judge, we have Rashawn Giles and Markel Johnson that'll be full hearings. They were not offered consents.
All right, Giles, come up to to the seat, and Johnson, where are you? Come up to the front row. Okay. All right, actually, I'm gonna move y'all back each one. So you go back to the front row there, and then you go to his seat. So
I go out here, sir.
you're fine. You sit down. You go sit on that front row there. You're Giles, right? Okay, then we're where we're supposed to be. All right, Mr. Giles, raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down. State your full name for me.
Rashawn Antoine Giles.
Mr. Giles, you're here today because your sentence enforcement supervisor has filed paperwork with me alleging that you are out of compliance with your probation. Do you understand what you're doing here today?
Yes, sir.
You understand you have the right to have an attorney represent you?
Yes, sir.
And you're here representing yourself? Is that what you want to do?
Yes, sir.
Got it. Okay. All right, Director Matthews, do you have a recommendation at all?
I do.
You do? Okay, so Director Matthews is gonna read out two things. She's gonna read out the allegations, and then she's gonna read out the state's recommendation on your case. If you accept it, I'll very likely follow that recommendation, although I'm not bound by it. Do you understand that?
Yes, sir.
And if you reject it, then we'll pivot over into a hearing. And at the end of the hearing, I will make an independent decision on two things. A, whether or not there's enough evidence to revoke your probation. And if there is, what should the court's response be to that? Do you understand? Those are the
Yes, sir.
options. Okay. All right, Director Matthews, floor is yours.
Judge, on 25 TK 5490, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendant's failed to report to probation as directed, having missed 2 out of 3 scheduled appointments. He's failed to pay the court fines and fees as ordered or utilize community service work in lieu of the court fine, being in arrears $281. Judge, the recommendation of probation on this case is to revoke 30 days and terminate the balance.
Okay, Mr. Giles, two questions. Number one, do you admit to the violations or do you deny the violations?
I admit to the 1 out of 3. The last time I came in was July the 15th, and the lady at the front desk, I gave her payment, and I said, "Was my probation officer here?" She said, "No, you can leave." It's the camera will show it. I swear to God, Mr. Thacker.
Okay,
I
well,
came in on July the 15th, so I
Alright.
do agree that I missed 1, but I didn't miss 2 out of 3.
all right, I'm just gonna call that a denial. Do you admit or deny the second one about getting behind on your fines and fees?
Yes, sir, I did. I got laid off, but I got a new job now, and I get paid on the 30th, so I can pay it. The day is the 27th.
So you missed 2 out of 3 appointments or you missed?
I missed 1 out of 3. The last time I went was July the 15th. And the
Okay.
lady, I can verify it.
I'm gonna ask, so I'm just gonna be very careful and do this one last time. Before I take over and I make my final decision on your 580 days, do you want to admit or deny the allegations?
I won't admit it. I don't want to deny it.
Are you admitting all the allegations?
Yes, sir.
Okay, well, I'm gonna put that he's pivoted to a full admission and I'm gonna accept it. So what's about to happen is, I had 580 days on the table that I could have revoked. The state's recommending that I revoke 30 days and close your case. And so I'm gonna follow that recommendation, okay? Is that your understanding of what we're about to do?
I don't know what you mean. Well, I got to do 30 days.
That's what they just
I
said.
understand.
I asked you if you, okay,
I mean, I'm saying.
do you admitted, do you accept the recommendation? Yes or
Yes,
no?
sir. I
Okay.
accept it.
All right, well then that's where we're at. So where we're at is, just to make sure we're on the same page. They read out the allegations. After a little bit of back and forth, you admitted, which is fine. You're still welcome to change your mind and deny until we get this thing finalized. And the recommendation Director Matthews read out was 30 days to serve and terminate the balance. And I'm asking you if you accept that or
I
not.
do.
Okay. So we have an admission, we have an acceptance of the 30 days to serve and the termination of the balance. And what you get is me not holding 580 days of your life in my hands. And so that's what you get out of it.
Yes, sir.
So, okay, with that said, actually, one of the deputies is gonna come over and put cuffs on you.
So what? Can I write something down, please?
So they'll work with you on all that.
We'll take care of that.
Yeah.
Ask me a question.
Hey, okay, hey, stop. Now, this is not your courtroom, and if you want to keep at it, I'm gonna do what the judge needs to do.
Do what we talked about.
Yes, sir.
We'll let you take care of this.
Thank
Hey, Bernadette, take him back here to the room and see what he needs to do. So we don't interrupt court when you keep going.
All right. Next case was, come on up and have a seat there. What was your name again?
Kayla Johnson. You're ready to shut the door. Thank you.
There we are. All right. Mr. Johnson, you're here today on 24 SR 0715. Raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay. Mr. Johnson, no offer was given to you prior to this hearing. Do y'all have an offer that you would like to extend? Does the
I
state?
have a recommendation.
Okay, recommendation. All right, so Mr. Giles, so you just saw how the last hearing went. So I've sworn you in. I'm gonna go through a couple odds and ends with you. The state, sentence enforcement is gonna read out 2 things: the state's recommendation from the solicitor on your case. I'm sorry, in reverse order. In this order, the allegations that are being made, and then whether or not what the recommendation is. And then I'm gonna ask you if you admit or deny the allegations, and if you accept or reject the recommendation. You with me?
You with me?
Yes? Okay.
Yes, sir.
Do you understand that you have the right to have an attorney represent you?
Yes, sir.
And you're here representing yourself?
Yes, sir.
Is that what you want to do?
Yes, sir.
Are you ready to go forward with your hearing?
Yes, sir.
All right, Director Matthews, the floor is yours.
Judge, on 24 SR 0715, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendants failed to report to probation as directed, having missed 3 of 8 scheduled appointments. The defendants failed to pay the court fines and fees as ordered, or utilize community service work in lieu of the court fine, being in arrears $317. The recommendation, judge, on this case is to revoke 30 days and terminate the balance.
All right, so 2 questions. Mr. Johnson, first question, do you admit or deny the allegations?
I admit.
All right, and do you accept or reject that offer?
I accept.
Okay. All right, you had 67 days left. So you had less exposure than the other individual, but I think that that's a reasonable recommendation. I think it closes your case and gets you off. Yeah, because this isn't working. So, okay, I agree with that. So what I'm going to do is I'm going to find that with your admission, the recommendation is proper, it is appropriate, it closes out the case, and it cuts you loose from being in my orbit. There's no consecutive cases or anything like that.
Now, Judge, would you, I don't know if Mr. Johnson is interested, but I'd be willing to leave the option, if someone wanted to come to the office and pay the remaining balance, he could be released without serving the 30 days.
Sure.
I have more than a good portion I could pay right now.
I could tell him to turn himself in on a date certain.
Well, I would still just have him go into custody today and someone else could pay
Oh,
the
yeah,
payment
that
of
would
the
be good.
513 and then we would just prepare the paperwork.
I
to
like
release it.
that plan so much.
I
better.
would say
Let's do that.
I got
I
300 I could put down right now.
Okay, so what I'm gonna do is, so I am gonna have you taken into custody. But what, since enforcement is giving you, in that mortal words of that country song, one more last chance. So just get this thing closed and
I've
get
been
me in your back.
trying to. Life been life.
Yeah, life is life. So you had about 8 exit ramps that you passed. This is your absolute last exit ramp before you just go sit in the jail.
Yeah.
So don't volunteer to go sit in the jail. Get your case closed. Get somebody to go get this thing done and get you off our radar, okay?
Okay, so just in order to not go to jail today.
That's not an option. You're going to jail. It's
I
whether you
gotta
stay
go.
there or not is the question.
What was his final amount, Marty?
513.
So 513. And again, I don't have a preference, but they're offering it and I'm saying, if you want it, you can take it.
I have 300 I could pay right now.
I'm not in that part of it. My job was just to have this hearing, set this backstop and be done with it.
You know what
So,
I'm saying? She
all right,
said,
so go with Piper. You're
I'm
going to be,
talk to you in a second.
they're going to come talk to you is what my point is, that they're going to talk to you off record outside there to figure out all the details. Okay. You're not being like hustled off. They're going to sit you back there and talk to you before it all happens.
I'm sorry.
There's those 2. Okay. Forum's empty. Let's just run through the calendar because